Good day, everyone. Thank you for taking time out of your day to learn about best legal practices in owning and operating rental property. In this presentation, we're going to talk about renovation plus evictions. Renovictions. My name is Bita Delisi. If you already haven't done so, head over to our social media, like us, follow us on Facebook and Instagram. The QR code at the bottom left of the slide, if you scan it with your smartphone, you will automatically add us in as a contact. If you ever have any questions regarding landlord and tenancy matters, feel free to reach us at info@stonegate.legalservices.ca. So let's get started. My name is Bita Delisi. My path started in real estate in and around 2004, 2005. Alongside that path, my landlord and investor clients started acquiring commercial properties such as multi-residential buildings and commercial plazas. And alongside my husband, we started a property management company, Stonegate Property Management, to manage these properties and act as a blanket to help deal with the day-to-day operations. Through that path, I would often end up going to the landlord and tenant board due to non-payment of rent, persistent late payment of rent, maintenance and repairs, all that fun stuff. And 9 times out of 10, my matters would get dismissed because I was not a licensed paralegal or a lawyer. So I went back to school, I obtained my paralegal license, and our business just shifted. Now, all our legal firm does is that we provide support to realtors and investors. So for the purpose of this presentation, everything we discuss is for information only. If you have a question regarding a legal matter, or if you have a matter that we can assist with, connect with us after the presentation. So one of the common questions we get asked at least daily is, can we evict the tenant to sell a property? Or the tenant isn't allowing for showings, can we kick them out? Or the landlord's lease is coming to an end, can we give the tenant notice to move out? The answer to all those questions is no. All tenants have security of tenure, and that means that tenants are entitled to occupy the rental unit after the lease comes to the end of its term. You see, a tenancy can only be terminated in one of 3 ways. Number 1, if the tenant decides to leave and gives notice. Number 2, by mutual agreement, the N13 agreement to end the tenancy. Or number 3, by way of a court or board order. Let's talk about a notice of tenant to end the tenancy because the landlord wants to demolish the rental unit, repair it, or convert it to another use. This is the N13 form. Realtors, please do not serve this notice. You are not licensed legal representatives. You cannot serve notices when you're not licensed to do so. Reasons for termination on the N13. Number 1, to demolish. Number 2, if you require the unit to be vacant in order to do renovations or repairs that are so extensive that building permits are required, and the unit must be vacant in order to commence work. You must note that the tenant has the right to move back into the rental unit once repairs and renovations have been completed. And they must provide the landlord with their letter of intent before moving out, so before the date of termination. Or number 3, to convert the rental unit or complex to a non-residential use. Let's talk about permits, because the landlord must indicate, number 1, if they have obtained the necessary building permits or other authorization to convert, demolish, or repair the rental unit. Number 2, if they have obtained the necessary building permits or other authorization to convert, demolish, or repair the rental unit. Or number 3, no permits or authorization are necessary in the case you need to convert the rental unit or demolish it. Let's talk about the termination of tenancy. Termination of tenancy on an N13 must be 120 days. The tenant has the right to terminate tenancy by providing 10 days notice to the landlord. The tenant does not have to move out if they don't agree with this notice, and the landlord must apply to the board for a hearing. The landlord and tenant board, at the landlord and tenant board, the landlord must provide evidence to the landlord and tenant board that they require the property to be vacant in order for work to commence. Let's talk about compensation. So for the reason to demolish and convert the property, if the property has 5 residential units, at least 5, the landlord must either pay an amount equal to 3 months rent or offer another rental unit acceptable to the tenant. If there are fewer than 5 rental units, the landlord must pay amount equal to 1 month's rent or offer another rental unit that's acceptable to the tenant. If the landlord requires the unit to be vacant in order to do repairs or renovations so extensive that building permits are required and the units must be vacant in order to commence the work, if the property contains at least 5 residential units and the tenant is not planning on moving back in, the landlord must pay an amount equivalent to 3 months rent or find another unit acceptable to the tenant. If there are 5 units and the tenant If there are fewer than 5 units and the tenant is not planning on moving back in, the landlord must pay amount equivalent to 1 month's rent or offer another rental unit acceptable to the tenant. If there are 5 units and the tenant is planning on moving back in, the landlord must pay an amount equivalent to 3 months' rent or pay the tenant the rent for a period of time the rental unit is being repaired or renovated, whichever is less. If there are fewer than 5 rental units and the tenant is planning on moving back in, the landlord must pay an amount equivalent to 1 month's rent or pay the tenant the rent for the period of time the rental unit is being repaired or renovated, whichever is less. How can a notice be served? So let's talk about that. One thing I love about the real estate industry is that it's really evolved with technology. And what I mean by that is that landlords are using their telephones, so their smartphones to, purchase real estate. They're using e-document, e-signature tools to sign. However, the wheels of justice spin very, very slowly. And what that means is that landlords must serve tenants in accordance to the rules of procedure of the Landlord and Tenant Board in the following ways: by handing the document to the tenant, handing it to another adult in the rental unit, placing it in the tenant's mailbox or where mail is usually delivered, sliding the document under the door or through a mail slot, faxing it to the tenant's place of business or residence, courier, registered mail, express post. Please note, if you're serving this document via mail, registered mail, express post, you must add 5 additional days to the date of termination. Realtors cannot serve these notices. Please don't serve these notices, because as a realtor or property manager, you don't know the consequences that come with serving these documents. Let's talk about the delays at the board, because pre-COVID, it took an average of about 4 to 5 months to obtain a hearing date. The board closed down between March 16, 2020, and they started holding video and telephone hearings on August 1st, 2020. So during that period of time, the board incurred about 80,000 applications. 90% of those applications were landlord applications, more specifically the N13. Currently, the average amount of time to receive a hearing is about 9 to 12 months. However, from my experience, I have to say the board is working effectively through all of that backlog. So what's the alternative? The alternative is what I call cash for keys. And cash for keys is not a DIY. It's not something that the realtor or property manager should get involved in, because quite frankly, you don't know the consequences that come along with the cash for keys. And the cash for keys is exactly what I call it. It is basically offering an incentive proposal to the tenant in order for them to end the tenancy. This offer can be anywhere from 5,000, 10,000, 20,000. We've had as high as 70,000, 100,000, 150,000, whatever it is, something that all parties agree to in order to end the tenancy. The legal representative will negotiate the terms directly with the tenant to facilitate a successful termination of tenancy. They will also draft a consent agreement and an N11. We spoke about the N11 earlier. That's one of the ways you can end tenancy. That's by mutual agreement. The N11 is a very heavily weighted agreement, because at the time that it's signed, all parties, more specifically the tenant, is giving up their rights to the tenancy. And the N11 will then be filed with the landlord and tenant board for an ex parte order. And an ex parte order is basically a fancy legal term for an order to terminate tenancy and evict the tenant without a hearing. So the cash for keys is an expedited way to ending the tenancy, of course, because there's cash involved. The timing it should take to facilitate and close on a cash for keys is anywhere from 30, 60, 90 days maximum to receive a board order. And the legal representative will arrange for keys to be picked up. Realtors, again, please do not get involved with serving or drafting or trying to do a cash for keys. If you have any questions, our firm does a lot of the cash for keys. We're more than happy to help. We're coming close to the end of our presentation. This is the Landlord Mastery. Head over to landlordmastery.ca, sign up for your free guide. We never sell any of our materials. All our materials are giveaways. The Landlord Mastery Guide is a guide that my husband Rob and I have put together from our own experience, both as realtors and landlords and legal representatives. It gives you access to a Google Drive where Rob often updates. In that Google Drive, you can find scripts, forms, other agreements, notices of entry, basically how to own and operate your own rental properties. Feel free to send it to your clients so that they can own and operate their own rental properties. We've come to the end of the presentation. Thank you so much for listening. Again, if you already haven't done so, head over to our social media, like us, follow us on Facebook and Instagram, scan that QR code, add us as a contact in your smartphone, and feel free to contact our firm, info@stonegate legal services.ca, if you ever have any questions. Until next time, bye for now.